All right, good afternoon and welcome back to those of you who were in attendance at the Bureau of Automotive Repair's advisory group meeting that took place in this very same room and via WebEx from 9:30 to 1 today. I want to welcome you back from lunch and welcome you to the regulatory workshop that we've scheduled today. My name is Patrick DeRay. I'm the chief of the Bureau of Automotive Repair, and we are holding a workshop to discuss draft regulations entitled Storage Fees Charged by Automotive Repair Dealers. We have a presentation, to give to you today. That'll be done by Matthew Gibson, who's sitting before me at the table. Matthew is a program manager with our field enforcement and field operations branch, and recently attended a number of presentations on the road. Last week we addressed the Society of Collision Repair Specialists on this regulation package, as well as another regulation package dealing with tear down disclosure requirements for automotive repair dealers. And then we followed that up with a couple of presentations to the California Auto Body Association, their chapters in Los Angeles, Orange County. It's kind of two counties combined into one. Really good meeting with close to 100 people in attendance, and that was very helpful for us to get some really good feedback on the package. And then the next and final night, we were in San Diego addressing the San Diego chapter of the California Auto Body Association, also known as CAA. I'll refer to them as CAA sometimes, to talk about this regulation package. Matthew's presentation will cover the latest draft that was posted on our website and is the work following our last workshop. We've held 3 to date, going back to April of last year. We had one in April, in July, and in October, and have made substantial changes after each workshop based on the feedback we've received, which has necessitated, in our minds, the need for holding another workshop to explain some of the changes that we've made. I'm hopeful this will be the last workshop. I'm not guaranteeing it, but we're at the point where we're looking to move this package forward. There might be some, and I think we've already decided there will be some changes as a result of the feedback we got last week down in Southern California. Some really good comments, as I said, from CAA members who hadn't been able to participate in prior workshops. So we've already discussed that, and we'll be sitting down next week after today's workshop to make those changes. But we're ready to move the package forward fairly soon. I'm hopeful we'll get it forward to our department for review. We've already had our legal office look at the regulation text. There's a lot of supporting documentation that will actually have to be submitted with the regulation text at some point when we're ready to file those regulations. They'll get an internal review at our department, a fully vetted review by our department budget, fiscal office, and our legal office, and then they'll ultimately go up to our agency, at which time, once they've been approved, we'll file them with the Office of Administrative Law. That's kind of the gatekeepers for all regulations filed by state of California agencies and departments, and that begins a formal 45-day public comment period on the proposed regulation text. So this is by no means the last opportunity to weigh in on this package. We're looking today for very substantive comments on the regulation text. We've heard all of the reason we're doing this is because we've heard all of the stories, all the finger pointing back and forth between the two industries. We've even heard from consumers who we stand in the shoes of when they file complaints with us. So we're pretty well aware of the issues out there, and we have done our best to address the statutory authority that's been provided us to move forth with regulations to clarify and fill in some of the gaps that legislation didn't do. It just gave us the authority to address this through regulations, which is why we've moved forward with this package and have been holding the workshops. I have some attendees from BAR coming in. Anyway, that's what we're going to do. After the presentation, we'll open it up for some comments. One of the individuals who's been very involved in this process in developing these regulations and helping us and guide us is sitting to my right at the far end of the desk here, Jack Molodanoff, who represents the California Auto Body Association and a couple of other trade associations in the automotive repair industry. So I want to thank him for joining us again. And but by no means will he be the only, I'm sure, commenter or speaker today responding to the latest draft of the regulations. So I think that's it, right? I'll get to that after Matt's presentation. Thank you. Let's proceed, Matt, and welcome. Thank you very much, and thank you for joining me last week on the road to do the presentations on this package.
Thank you, Pat. And as Pat said, I'm Matthew Gibson, Program Manager with the Bureau of Automotive Repair in the Field Operations and Enforcement Division. And this is the fourth workshop to discuss the proposed storage fees charged by automotive repair dealer regulations. I'm just going to say that the name is actually different. This is the first time we actually changed the name of the regulations. The last three workshops, it said storage fees, storage and towing fees for automotive repair dealers. So I was just acknowledging that the name actually changed. The proposed regulations are drafted in accordance with the authority provided by Assembly Bill 1263, which authorizes the Bureau to clarify existing statutes that govern storage fees. My PowerPoint today is 7 slides and will cover the concepts the Bureau intends to include in the proposed regulations. Proposed text is a rough draft which is intended to solicit input, and we recognize that there will be changes based on our discussion today, as well as internal discussions at BAR and DCA. And as Pat mentioned, we were fortunate enough to have been invited to some CAA chapter meetings in Southern California. As a result of those, there's some modifications we probably are going to make as a result of some of the comments. And as we go through the PowerPoint, I don't know that they're all covered in the PowerPoint. I will point them out. Or if anybody makes a comment about any of the sections that we received a comment on, I will also point them out at that time so that you kind of know what we're thinking related to those possible changes. All right. So the purpose of the proposed regulations is to clarify BAR's authority to address storage fee issues. It's to codify the guidance that BAR has been giving the automotive repair industry about storage fees for the last 6 years. And it's to bring together existing laws governing storage fees from the Business and Professions Code, Civil Code, and California Vehicle Code, there we go, under one unified regulation. Next slide. So the proposed regulations will add a new subdivision A2U to California Code of Regulations 3351, which is the regulation that spells out everything that's required by our automotive repair dealer application. It will require that ARDs that charge storage fees resulting from an accident or a theft recovery to report their maximum daily storage rate to BAR as part of the initial registration and renewal process. And it will allow ARDs to change their reported maximum daily storage rate once per registration cycle. Two things I was going to point out about the reg text, the actual reg text, but also what I have on the slide here. There was some thought that, or there might have been some confusion, that the allowing ARDs to change the reported maximum daily storage rate once per registration cycle was thought to mean that that was only at the time of renewal, when in fact we have intended it not only to be at the time of renewal, but at some other point prior to the next renewal, so the entire cycle. So The idea would be that when you renewed, you would report your maximum daily storage rate at that time. And then some point in the next 12 months, if you needed to increase it or decrease it, you would be allowed to do so. And so we will try to make sure that that's clear in the regulation text. One other thing I was going to point out is that some comments talked about very large vehicles, like buses, for example, or big rigs, vehicles that take up a larger area to store than a regular passenger car. And that the idea that that might be a lot more, that would be twice as much to store rather than a passenger vehicle. And we have had, that was a great comment. And based on that, we'll probably try to consider a way to to quantify, or not quantify, to classify the type of vehicle we're actually trying to get your maximum daily storage rate on in the regulation text. All right, so in addition to A to U in 3.351, we're also going to add a new E9, which will include the maximum daily storage rate as a material change requiring written notification or notice to BAR within 30 days of the date of making that change. It just means that if you do change your storage rate and it's not related to the renewal, you will have to let us know that you did it within 30 days of having done it. Okay, next slide. Proposed regulations will require an ARD that charges storage fees to post their maximum daily storage rate as reported to BAR. It will require consumer and third-party payer access to a stored vehicle. It will require a vehicle be stored at the ARD's business unless it is necessary for an ARD to store the vehicle at another location. But if they do have to store it at another location, they will have to notify the customer of where they are moving it to. And if they want to charge for that relocation, they'll have to get the customer's authorization to charge them for relocating the vehicle to an offsite location. The regulations will require an ARD accept multiple payment methods. And just to be clear, when we're talking about multiple payment methods, we're talking about cash, but also a valid bank credit card or insurer's check. And it will require an ARD that maintains a motor vehicle carrier permit to post the required towing and storage fee access notice. I don't know how many ARDs this is going to apply to. It's not zero. Any ARD that's also a tow provider or a tow company, you have a motor vehicle carrier permit and probably already post your towing and storage fee access notice. But anyway, now it's in the regs. Okay, next slide. Proposed regulations will create a search tool on BAR's website showing average and median daily storage rates for a given locale based on the maximum daily storage rates reported to BAR. It will define a locale as one of 4 geographic radiuses around each reporting ARD that is sufficient to identify average and median storage rates. And that those geographic radiuses are dependent upon the quantity and proximity of other reporting ARDs. So the first radius would be a 5-mile radius around a reporting ARD or repair shop. And if you think about it, all the repair shops that also report within that 5-mile radius, we will use all of those daily storage rates to generate an average and a median for that locale. However, if there's less than 20 repair shops in that 5-mile radius, the radius will expand out to 10 miles. And at that point, all the reporting ARDs in that 10-mile radius, those maximum daily storage rates that they're reporting will be used to generate an average and medium daily storage rate for that 10-mile radius locale. However, if there's less than 10 in a 10-mile radius, the radius will expand out to 20. If there's less than 5 reporting ARDs in a 20-mile radius, then the locale will go to the entire county in which the reporting ARD is located in. Also, the regulations will clarify that the search tool shall not be used to establish, suppress, or otherwise influence actual storage rates charged by an automotive repair dealer. Okay, the next slide. So the next new section, 3351.8.2, obviously the first one was 3351.8.1, but anyway, this would be storage fees resulting from a repair transaction. These regulations will require storage fees be charged in accordance with Vehicle Code Section 22524.5, but specifically storage fees resulting from an accident or a theft recovery must be comparable to ARDs in the same locale pursuant to 22524.5 C2B. Storage fees that are not comparable are still permitted if otherwise determined to be reasonable pursuant to C2B of 22524.5. And presumptively unreasonable fees shall include any term or expression of like meaning to presumptively unreasonable fees listed in Vehicle Code 22524.5 C3. So those are actually listed out as an admin and filing fee, unless that fee is related to dealing with DMV documentation or filing for authorization to conduct a lien sale. Security fees, dolly fees, load and unload fees, pull-out fees, and gate fees, unless the vehicle is requested to be released outside of regular business hours. I will point out one other thing about this particular requirement in our regulations. It's not unique to this regulation. We have other regulations that have similar provisions, such as our automatic transmission regulations that say that you have to meet certain requirements if you're saying that a transmission has been rebuilt, or if you use any term of like meaning. Same thing goes for an air conditioning service. You have to, we don't say that it has to be an air conditioning service, but any term or diagnosis, any of those terms or terms of like meaning mean that those regulations apply in that situation, as is the case here. All right, can I get the next section? Next slide. Oh, did I skip it?
I think you skipped the last
Oh, I apologize. Thanks, Pat. This regulations will clarify that performing teardown as defined in CCNR 3353C is a repair. We felt it was necessary to clarify because there seemed to be some confusion expressed in some of our prior workshops. All right, now can I get the next slide? All right, the proposed regulations will require additional storage fee notification when providing a teardown estimate. It will clarify that no storage fees can be assessed while a vehicle is undergoing repairs, including a teardown. It will establish that an ARD must have obtained their customer's authorization, generated an invoice after completion of the contractor repairs, and notified the customer the repairs are completed prior to charging storage fees. And it will require an itemized invoice of storage fees when charged. Yes, sir. Proposed regulations will require an ARD when receiving a vehicle where the registered owner is not present or is unknown to contact the owner and notify him of receipt of the vehicle, and either obtain authorization to proceed with the needed repairs, or if no authorization is provided, or the ARD cannot or will not repair the vehicle, notify the owner if they intend to start charging storage fees. One thing before I move on to the last bullet, I wrote that it's written differently in the regulations, but specifically has to do with the idea that if you inspect a vehicle as a repair shop and you are not certified to work on that vehicle, such as was expressed, I think, by Gene Lopez at our first workshop about a Tesla that showed up at one of the Snyder Collision Centers. They weren't going to work on it, and that would be a perfect scenario by which I'm not working on that car, you need to remove it, or I'm going to start charging storage. Or, as I've been professing to the industry for the last 6 years, if you find that is a ball of metal that has been delivered to your repair shop and it doesn't seem repairable, and you will not be repairing that vehicle, then you could call your consumer and just say that I will not be repairing this vehicle, and then tell them that you're intending to start charging storage fees. The last bullet is that these regulations will, if after 3 attempts the ARD is unsuccessful in contacting the registered owner, the ARD may begin charging storage fees in accordance with Vehicle Code Section 22524.5 C2A, not C2B. C2B would be the subdivision within 22524.5 that talks about rates being comparable to other repair shops in the same locale. C2A would be what I think the industry pretty much calls the CHP rate, but we call more like the public agency rate. And if you get to the last slide, that's it. That's the PowerPoint.
Thank you, Matt. Good job. That was very similar to the presentations we gave to the CAA chapters last week, virtually the same. And appreciate you doing this once again. I'm going to open it up for comments. I'm asking to help us really get to the bottom of the issues. Please drill down into the specific regulation text that is of interest to you, that you would seek a modification or have a question about if it's not clear to you. We've got the regulation text posted on the screen. We also had did we make copies available, hard copies available at the front of the room? And it's also posted on our website, the latest version. It was done with the notice that went out about this workshop. So you'll see them right before you. All right, I'm going to open it up for comments, and please we've got potentially a number of speakers. I realize that, both in person and virtually. We are having this the WebEx virtual platform is being used to allow for people who couldn't be here in person today, and we will welcome comments from those individuals as well. It also is being webcast. I forgot to mention at the beginning or outset of the meeting that we are doing this via webcast. So that means a recording is occurring of everything said in the room. So if you forgot something that was said or committed to, or just want to go back and rehear the meeting today, that'll be posted on our website about a week from now. So sometime later part of next week, I'm expecting that would be available. And then lastly, something that you didn't think of or didn't have time for because we have allotted roughly 2 hours for this workshop, you would like to follow up with in writing, we will always accept a written comment. By no means, if you fail to say something or don't get it all on the record today, that doesn't mean you can't weigh in on this regulation package. We'll take written comments all the way up until the time they are adopted. And as I said, once they are filed, once we're beyond the workshop process and we file the regulations, there's a formal public comment period of a minimum of 45 days to be able to weigh in on the package. So lots of opportunities still to weigh in. Yes.
I apologize
Matt.
before we go. Just one thing I wanted to add. Hey, could you go back to number 6?
Thank you.
Presumptively unreasonable fees, one of the comments we got back during our visits to the CA meetings in Southern California, there was a request that, I don't know, it had to do with the concern, I do know, I'm trying to think of the best way to express it. It had to do with the idea that perhaps presumptively unreasonable fees is really being construed as an unreasonable fee, but we know that a presumptively unreasonable fee is actually only presumptively unreasonable, but that presumption can be rebutted with evidence. And one of the people at one of the meetings, and I don't remember specifically who at this point, had requested that we add some language into the section about presumptively unreasonable fees, about the fact that that if they had evidence, then that presumption would be rebutted. And I think we thought that was probably a good idea. And I wanted to mention that
before we got into before we heard the comment about it.
I might have taken the whole comment off the table now.
Right.
Saying yes.
Yes. Thank you. All right. Let's open it up for comments. And I think I'll turn to my right. You're the only one brave enough, I guess, here to join me at the table. Thank you very much, Jack, for being here again, as always, representing the California Auto Body Association. We look forward to hearing what you have to say on this latest version of the regulations.
Well, first, let me just say thank you for working on this. And I know there's been a team effort. I've heard of 1 workshop, 2 workshops, maybe 3 workshops is very, very rare. And I've never heard of a 4th workshop. So I know you've put in a lot of time. You've listened to a lot of comments. You've made a lot of revisions. But this is a big issue to the industry. Obviously, there's some controversial issues here. But I wanted to thank you for the work and listening to the comments and making, revisions and also attending or getting some outreach from actual members out there who could not attend this particular meeting. So let me try to follow the chief's comments about zeroing in and trying to, talk about the specific sections, the text sections, and then also offer maybe some suggestions for consideration. So on the regulations, let's go to page 2. There's a timer on there. It's kind of hard to see. I don't know if the members of the audience can see.
Yeah, we'll address that in a minute.
Okay.
Okay.
Let's see. Let me just start off with 3351.81 A. And it says that you have to have display the sign, which is fine. And then it talks about at the end of the sentence says, in a conspicuous place where the storage rates are visible legible, and adjacent to the counter where the customers are served. This adjacent to the counter may be very limiting, and I'd like to at least have you look at the current law where the BAR sign, which is under 3351.3, which says displaying in a place in a manner conspicuous to all customers. So in other words, this language, the way I read it, it's got to be adjacent to the counter. And I don't know, why shouldn't it be in the front of the door or somewhere else where the consumers can see? So I just think it should be consistent with your current regulations where, so I don't think that's a big deal. I just think it should be consistent with 3351.3 if you take a look at that.
Take a look at that one.
Yeah, take a look at that. Under 3351.81C, it says an automotive repair dealer charging for vehicle storage shall permit the customer or the customer's third-party access to the vehicle for inspection during normal business hours. So the operative word there is charging. The way I read this is if you don't charge for storage, you don't have to let the customer inspect. I just like to bring to your attention that there's some direct repair programs that may not, they get referrals, they may not charge for storage. And, that's a contractual relationship. So the way this reads now is that since that particular automotive repair shop does not charge, the customer doesn't have a right to go inspect the vehicle. So I think this is very limiting, and I think you need to, revisit that issue here. Okay.
Very good.
Let me move on to page 3. Get into some more of the maybe more controversial issues. This has to do with G. Utilizing the daily storage rates reported pursuant to Section 3351A2U of this chapter. The Bureau should create this search tool. We've been referring it to as a search tool during a survey, basically. And you're going to post it on the website. And I think, and then as a reference for the public third-party payers, which means, insurance companies, and then it goes further down, talks about G1 talks about that the locale will be defined and defined as the geographical radius around each reporting automotive repair dealer that is sufficient to identify the average and median storage rates within the locale. The concern there is that once you start doing these surveys and coming up with an average, there's unintended consequences where an insurance company will never pay over the average. They'll just say, we're not going to pay over the BAR has done a survey and here's the average. And that's the concern. I know that in section G2, you say published storage rate shall not be used to establish or otherwise influence the automotive repair dealer storage rates and shall not be used to limit or suppress the automotive repair dealer storage rate, which is great. Unfortunately, how's that going to be enforced? I mean, you don't have any, if the insurance company says, hey, we're not going to pay over the average, why would we pay over the average? I don't, and how do you enforce that? How does the shop enforce that? I mean, I don't know, maybe if you put in a private right of action, language in here, maybe the shop can enforce. Maybe it's something to consider, a private right of action for the shop to take if an insurance company wants to cap their rate at the average. I'm throwing that as a suggestion. And I don't know whether you really need to make this public. I think making this public creates unintended consequences, and the concern is if you want to collect the rates, which you have every right to do. I don't think there's any issue about collecting rates. You can call shops and collect rates. Anyone can do that. But publishing and determining averages is something that should be an internal tool. Our recommendation, and we've talked about this, is you can do this, but why don't you play poker? Keep it internal. Why? I think publishing it creates unintended consequences, and that's a big concern. Okay, let me move on. page 4, 3351.82 B1. It says there that the shop on the tear down estimate will have to provide the following information: the number of days, and then it says not to be less than 3 business days the customer has to authorize repairs or remove the vehicle prior. That is essentially saying that the shop has to give away three days. That's what it's saying. 3 free days. And I'm not aware of any law or any governmental entity that tells a small business owner, you know what, you can't charge for a service. If the shop wants to give free storage for 3 days or 5 days or 7 days, that's their option. And if they don't want to give any free storage, they don't have to. I really don't know where the authority comes from that to give. I mean, I just think that, it's like the state telling you have to work 3 days for free. I mean, I don't think there's any legal authority for that. I don't think you can do that. And the recommendation is to strike not to be less than 3 business days. Let the shop make that determination. Let them say, you got 7 days, 5 days, 1 day, but they should determine, and not the government should be telling the small business owner, you have to give 3 days of free storage. Okay, let me move on to page 5. Let's see. So this section 3351.82, as I read this, the repair facility will under this section, if they do a tear down, according to the language in here, they will be able to charge for storage provided they meet the requirements here, and they would be able to recover the retail rates, not the CHP rates. Is that correct?
And I want to make sure I understood. You said the top of page 5, so we're talking about D, like.
Oh yeah, I'm sorry. I'm still talking about storage fees resulting from a repair transaction. And it goes from 2 pages. The way I read this is that this is where the repair shops will fall into. Most of the legitimate auto body repair shops that are repairing collision, doing repairs, that's their primary business. They're not in the business of towing and storage. They're just they're repairing cars. When the car comes in, they do a tear down. And they can charge their retail rates basically under this section. That's the way I read this.
And by retail, yeah, the daily storage rates.
The daily storage rates
Not
that in the
CHP.
geographic, not the capped CHP rates that are primarily used for towing and storage yards.
That is correct.
Okay. But I don't see anything in here where the legitimate, again, small business owner, the car comes in, it is a ball of metal, okay? Because every transaction in 3351.82 is consensual. The vehicle is towed in because someone wants that car repaired. It came in from a tow and storage yard, or someone wanted the vehicle repaired. That's why it's there. It's not there to be stored. So again, the business owner, the collision repair facility inspects the vehicle, and it's a ball of metal. In their opinion, they can't repair it, right? I mean, it's pretty clear at that point. I don't see anything in this section that would reference that, and where the automotive repair dealer, the body shop, would get paid their retail rate in that scenario. In other words, a car comes in, they want to get it repaired, and they're being legit, they're being honest. They're saying, I can't repair this car. Get it out of here, okay?
So in D of 3351.8.2, you're looking for some kind of reference back to vehicle code 22524 C2B?
Correct. What I'm saying is that you're penalizing the honest automotive body shop because they're saying, hey, I can't repair this car. It was brought in consensually, right? Someone wanted the car repaired, but the shop says, I can't repair it. Why are they, because they would be penalized here. They wouldn't be able to get the retail rate.
So I will point you real quick to page 6 with 3351.8.3 A2, that's where we covered that scenario where they would be entitled to that retail or that C2B rate.
Yeah, but that section, the way I read it, is a little confusing, I know, but 3351.83 talks about a registered owner notification. And I can tell you that no legitimate automotive repair body shop will fall into this category because they don't deal with registered owners. They deal with customers. That's the Automotive Repair Act. They deal with customers. Someone wanted to have their car repaired. This section is really, what you're trying to define here in a clever way is towing and storage yards. That's their primary business, right?
Thank you for recognizing as clever.
But no legitimate auto body, none of my members, because they repair cars. They're not in the business of towing and storage. They're not going to, they don't deal with registered owners. That's not what they do. They deal with customers. So I'm saying that section that, about inspecting, that you said we took care of it here. Yeah, you took care of it, but they would be capped or stuck with the CHP rates. I'm saying put something above in this under repair.
Under the D.
Under D, yeah, exactly.
On point one.
Exactly. Do you understand that?
I got it.
The point is like, we shouldn't be penalizing someone that the car was brought. A customer says, can you please repair my car? And the shop says, you know what? Okay, what do you want me to do? I got to do a tear down to get my retail rates? That doesn't make any sense. They're going to say, listen, I can't repair the car. I'm sorry. I mean, I just, based on my knowledge, I can't repair the car, but they should not be penalized and get stuck with CHP rates. That's my point.
So it does get into C2B, Vehicle Code 22524.5, C2B earlier in that 3351.8.2 under A1.
But see, what I'm suggesting is to add E after E or F, add a G in there and say, if the ARD is after performing the visual inspection of the repair, the ARD can notify the customer that they can't, they won't be able to, repair the vehicle, and they start charging the rate. It's just like you have in A3, but you got to put it up in A2 so it's covered there, because that's the section that's the legitimate auto body shop is going to fall under, and they should be able not only a repair, but if they can't repair it either, again, it's brought in consensually. If you want to put in, they intend to repair it, because every car that comes into a legitimate auto body shop is consensual. That's why it's there. I mean, it'll get repaired. It may not get repaired. Well, but
I'm not talking, there are some situations where cars end up at body shops in a non-consensual way.
Well,
but fair enough. I accept the
if
point.
those are bandit tows or anything like that's going to fall under 51.83. I mean, if the shop doesn't know where this car came from or whatever, that's a towing and storage yard. And I don't know if you need to define, maybe this is a time to really define, primary business is, repairing the vehicle, or, your primary business is towing and storage, towing, storage in a body shop scenario. The body shop scenario, any kind of storage is really ancillary. It's not their primary business. That's not what they do. That's not how they make money. And so I think something needs to be put into A2 that says that covers so the shop can get their retail rate if they don't repair the car and they don't perform what you call a tear down repair.
Okay.
That's I think that's only fair. They're doing the right thing. They're trying to be honest about it. You know what I'm saying? Because otherwise you're forcing shops now to do potentially a tear down and when they know that the car's not repairable. I think that's bad policy. I really do. I don't know why should be tearing down cars if it's a ball of metal.
I certainly wouldn't have told anybody to do that.
Yeah, but that's kind of how it's got to be addressed here.
All right.
Anyway, and then on 8.3, like I said, I don't think any shop, body shop that does, primary does repairs would fall into this category. This section here, you're really trying to define towing and storage. They deal with registered owners, and they deal. We deal with customers. Now, if you want to describe it as consensual, non-consensual, that's what these are. These are non-consensual. They get towed in. because they're bandit tows or whatever. They don't know where they came from. Those are not definitely our members. And like I said, I don't think 883 would apply to any legitimate auto body shop. So I think it may need to be clarified a little bit, using the terms consensual, non-consensual, defining towing and storage a little better. But I think we can improve this.
Okay. Just a couple
Yeah.
things I want to point out. Thank you for your comments. I
Yeah,
was
okay.
going to say, first one, you talked about this adjacent to a counter. That language is specific. It was used in the vehicle safety system inspection regulations. That's the reason why it ended up in this
Okay.
one. You referenced back to 351.3 and about this, about the sign being posted in an area that's frequented by customers. And that's why many Ronald Reagan signs ended up in auto repair shop bathrooms.
Yeah.
And so that's why we ended up getting more specific on where it had to be posted. I mean, possibly not saying that it needed to be adjacent to a counter, but fair enough, somewhere where customers are served, that we can obviously discuss it. And good catch on charging, by the way, on number C. I'm sorry, you were going to say something?
Well, I was going to say on the signs too, I believe you also have on the smog check signs, I think the language talks about conspicuous to all customers.
Yeah.
I don't know about the bathroom stuff. I mean, okay, that's baloney, but I mean, customer, first of all, I mean, I think, I don't even know if that would mean conspicuous to all customers because they may not use the restroom. So anyway, I just think adjacent to the counter is limiting, but take a look at that. And the charging, I'm glad. Thank you. Okay. Yeah.
Yeah. One thing I was going to mention that you didn't specifically bring up, but was brought up in one of the Southern California meetings, was about 3351 8.8.1B. And we've talked about this because it's been the subject of our last three workshops. It has to do with this idea that an automotive repair dealer charging for storage of a vehicle shall establish a daily storage rate based on the cost associated with storing a vehicle. There was a lot of feelings at those meetings related to direct repair shops or DRPs.
Yeah.
And that if we included storage rates for people or for ARDs that were direct repair facilities, that it would skew the maximum daily storage rate for a locale, because that rate would be contracted between the body shop and the insurance company for which they were doing this work directly. And it seemed like a very reasonable concern. It's certainly, if it is a contracted rate with an insurance company, I don't know that it's actually based on the actual cost associated with storing a vehicle. So I think we had some internal discussion about maybe it's worth making or looking at adding additional language to B to say something about the idea that, if the body shop is, or this ARD is contracted with an insurance company, that rate should be not reported. But I just wanted to bring that up because it was brought up in one of the CAA meetings.
Yeah, that's why I use the term retail. I mean, versus a contracted rate. I mean, that's not a legit. I mean, that's just you have a negotiated rate. I mean, I don't whatever you want to call it. Yeah, because you do a negotiated rate. That's not really market rate.
Right.
That could be anything, and so those generally should not be turned in. I mean, I don't. Anyway, yeah, no, I think that's a good point.
Yeah, I also came to the understanding or the realization that not all DRP shops are 100% DRP. I guess there's some that have some blend of DRP work and then regular DRP work. I'd want to find a way to make sure that it's clear that I want this rate, not the negotiated rate. So anyway, that was one of the comments that came up. Okay. The only other thing I was going to point out was the 3-day thing, just in case it comes up in some other comment. Not that it was a comment from one of our meetings with CAA chapters, but it is us trying to point out that the customer is literally the customer, but recognizing certain realities about the fact that we are literally putting the customer in a situation where they are going to have to contact their insurer and get them to move one way or the other to authorize the work. The customer can authorize the work. As a matter of fact, that's an automotive repair transaction, and that's exactly what we would tell anybody who asks about who the customer is and who can authorize the work. The only person that can authorize the work is the customer. But this three-party transaction that's been created can become problematic and result in extended authorization times as repair shops wait for an insurer who is not the customer to tell them it's okay to do work. In our mind, we're at least trying to say 3 days and then, but fair enough. I appreciate the comment.
Well, I mean, I think the customer will know in the teardown because you're going to list the number of days, right? Mm-hmm. I mean, it could be, I'm just saying, give the customer will realize, be able to read it and say, oh, you got 0 days, you got 7 days, you got 5 days. days. I'm just saying, you're requiring the shop to list the number of days. Fair enough, right? But let the shop make the choice as to how many days. They may want to give more than 3 days. Maybe not. Maybe they're going to give 1 day or 2 days, but at least the customer authorizing the repair, say, hey, we're going to have to make a decision. They have to deal with their insurance company and say, hey, this car can't be repaired. We're going to have to make a decision pretty quickly. I don't know where 3 days came from. Maybe you thought, that's a nice number. We plucked that out of the air. I just don't know what statute. I don't think there is a statute. I know there's not a statute out there. And what I'm saying is, I don't think, you got to look at the legal authority. How do because you're telling the shop to give away three days free storage. I just don't think the government can just tell you, hey, you can give free service. I mean, you can tell what shops you can't charge for diagnosis. I mean, I don't know. I mean, I see it the same way. It's free. Let the shop make that choice. And if they want to do that, that's fine.
Okay.
That's my point.
Fair enough.
Thank you, Jack.
Good comments. Yeah.
Thank you.
Yep. All right, let's move around the room here. Pete Bezek, you want to come to the table and we'll slide the microphone over to you? Yeah, right there's fine. Kindly introduce yourself to everyone who isn't aware of who you are, although I know you're a legend in this industry, so. I can't hear you in the back, Pete. Is it not? Is it okay? Pete Bezek with the
You didn't want me to,
California Auto Body Association.
he didn't want anybody to hear me. Okay, Pete Bessick, California Auto Body
Hey.
Association.
Welcome.
I got a couple points. The first one is that I think that you really ought to consider collecting separate rates for outdoor, indoor, and electric vehicle storage. And that third one is a big deal because the cost of storing electric, when you're asking for a rate, it's going to always include the electric vehicle. And I don't think anybody wants to be dealing with that one because it's going to be quite high. So a single storage rate really doesn't work very well. I kind of like to focus primarily on locale because that seems to be a bit of a problem. And we have a little bit of experience with some of that. The locale described in the regulation 3351.8.1G, a thorough 5 miles is far too great a distance to allow for a statistically fair and accurate result. The distance between the poles of this 5-mile circle, which would be 10 miles from north to south, 10 miles from east to west, will cross far too many economic zones and potentially cities where zonings, building costs, and property values will make the data useless and will likely be successfully challenged immediately. I would almost call this a kind of a fatal flaw in this particular regulation. A statistically fair and accurate method of determining a locale is a 1-mile circle with a minimum of 6 repair shops within that 1-mile circle. Now, if you, and I think that you probably use the Department of Insurance labor rate survey. Am I correct with that?
No.
The formula for the labor rate survey?
You mean as far as how this was made?
Yeah.
No, I've never seen it.
Okay. Okay. Here's why this is important. Jack Moldonoff, Monty Atherton, and me from the CAA spent 5 years developing that labor rate survey, and that's a lot more than 4 meetings. And Tony Signorelli from the DOI was a part of this. And And we had a lot of trouble determining the locale when we were talking about labor rates. We tried grids, we tried zip codes, we tried counties, we tried all those things and could not come up with a statistically valid number. So in order to resolve that, the Department of Insurance hired two professors from two separate universities in Southern California. These professors were experts in statistics. And then we, the CAA, actually, we hired one also, professor of statistics, or what the heck, from the University of Iowa. We used the responses from those professors to develop the locale in the standardized labor rate survey. And that's currently insurance code 2695.81. We can say we urge the BAR to use 2695.81 model as written in the insurance code to determine a statistically accurate storage rate when investigating complaints for these consumer complaints. It doesn't change. It basically is fundamentally the same, but it's the locale, the method of this determining where or what that number should be. And what we found is that the more you compress the circle, the closer to accurate the rates are or the charges are. And if there are fewer than 6 shops in that circle, then you extend it another 1 mile. And this works for rural areas, metropolitan areas, and it just works for every area. You just keep extending the mile. So it makes it a lot easier. Because you're collecting the data from every repair shop, theoretically, your numbers based on that criteria would be pinpoint accurate. And also, that methodology has already been approved by the Office of Administrative Law when we filed the labor rate survey. So that kind of, it's a simple thing for you to do. We urge you to do that. I'd like to make another comment. Jack you spent a lot of time talking about Section B on page 6. When a vehicle comes into a repair shop at the consent of the customer, that vehicle just doesn't automatically it finds itself a place to be put. Those vehicles are damaged, some of them more serious than others, but they're damaged. And that repair shop has to do some work on that vehicle. They have to have someone move that vehicle, get it in a stall, or put it in the shop. That doesn't come for nothing. Somebody has to pay for that, and that is the repairer. And even though he's not repairing the vehicle, he is doing work on that vehicle that they are deserved to be paid. And that is something that is included in their storage charges. Tow facilities that do nothing but towing, they're going to drop it right in their lot, and that's where it sits. But that repair shop has a couple of obligations. If you look at Section 3068 of the Civil Code, they've got to protect the property, that vehicle, from further damage. They've got to provide safekeeping. There's a whole lot of things that they have to do in order to do that and get paid for that storage. And I think you folks are forgetting the fact that they have work to do on those vehicles, that just to put them in storage. And by the way, if the shop doesn't have outside storage, that vehicle goes inside their building, and it has to come out during the work hours and go back in the evening. So you're completely ignoring those items that the shop has to do. Any questions? Because That's,
Thank you for your comment.
that's all I've got to say. Thank you.
Very good comments, Pete. Thank you very much. It's always good to see you.
Here, I'm gonna- Turn it back on. I want them.
Any other comments in the room here? Yes, I saw the lady here in the fourth row back or so. Yeah. And then I'll get you, Ben. Hi there, welcome.
Thanks for having me today.
Yep.
Hello.
Introduce yourself again for the audience and just so we have it on record.
Yes, my name is Erica Williams. I'm in-house counsel for CSAA Insurance Exchange. Thank you again for having this workshop. And again, for all the hard work over the course of the last year or so in creating these. I did note there's a lot of significant changes from the last workshop. And some of them are quite disturbing, to be honest, and I'll be frank with that, just because, and I'll share my insight on that. But some of these changes are also for the best, and I appreciate that. So I do want to open with that. There's mixed feelings with these changes. On the second page, I'll just dive right into it. The concern with 3351.8.1A when it comes to including a maximum rate. Here, it appears that the bar is allowing variable rates. And I understand, appreciate prior comments that there's a different cost associated with storing different types of vehicles, such as maybe a bus that was raised earlier. However, there needs to be consistency and a way to show the consumer, because that's what these regulations should be protecting, is the average consumer, not a shop and not an insurance carrier. They need to know when going into a shop what to expect, especially because they're not the ones usually taking their car there. It's usually by way of a tow. Allowing variable rates, unfortunately, opens the door for those shops that do not want to be reasonable and ordinary. I'm not talking about those shops who are fair. I'm talking about the outliers, the unscrupulous ones. They have a door to elicit unfair business practice and discriminatory billing practices on their consumer base, depending on whether or not a Royce, a luxury car comes in of any type, which we've seen, they charge one rate, hundreds and hundreds of dollars more per day versus a beat up Camry, just because of the car type or because they have an insurance carrier. There could be a number of different reasons why, but without a consistent way to show what their storage rate is, this regulation opens that door. Maybe a change that could be inserted is a tier for different types of storage that was presented, like inside, outside, or size of vehicle. Maybe that is a way to reach a compromise. But that is one issue that this leaves the door open for further litigation and argument, and hopefully these regulations are able to bridge that gap so we don't have to go to court with these down the road, either the shops, consumers, or carriers, and there isn't any room for argument on what is applicable in any given claim.
So let me just jump in here and ask a question back to you. The tier concept has some intrigue for me, but you don't think I don't know where the provision is. We've already addressed it, where it has to be based on actual costs. Doesn't give someone the right to say, I'm going to charge an older vehicle versus an newer vehicle or a different color vehicle or what have you, different rates. Doesn't that seem to address that concern or that issue of yours?
I think you're talking about subsection B here for the charging storage.
Based on the cost associated with storing vehicles, yeah. It should be a vehicle.
Yes and no, but again, allowing the variable rate, it does allow some inconsistency here, because it can be argued that the costs change. That's why there's variable rates. But how does the average consumer know? How are they able to know that they're being charged fairly for their car, especially because they're not the ones with the with thousands of totals that they have records on, that they can go to another adjuster and say, hey, what have you been working on lately? Or another shop who can go down the street and say, hey, like, I have all these types of cars. What are you seeing? Like, the average consumer doesn't have that right, and they're not afforded that ability. So I think these regulations should be designed to protect that average consumer.
Okay.
And then I wanted to make a comment because it was raised earlier on that section B, since we're on the topic about DRN shops, or the ones who have contracts for no storage, or a certain rate for storage with carriers. I will have to consider whether or not what our opinion is about the reflection in the statistics, that portion. But generally, I would assume that the contracted rate, yeah, it's a private rate, but that is part of their business, and it's incorporated into their overall cost, because usually with a benefit such as that, they get other benefits such as the volume of cars for repair. So they make up that in other ways in their business. They might be given a certain amount of referrals, or by zip code, or they're listed on a website certified by their certain expectations that they have to meet in an application process that they have to undergo to make those qualifications with an insurance company. So that does, I would assume, be incorporated into their cost of business as a whole. Whether or not that's reported or not, that's another issue. But I think as is, this language is fine in B, just for that reason. I have a lot of comments, but I'll send some red lines, but I just want to address the big issues. So I'll go to the next page here.
Which page is that?
Page 3.
3.
I think we're on G with the website tools, and it opens up with saying that this website tools is a reference for the public, third-party payors, and other stakeholders to identify average and median daily storage rates for the locale. However, jumping to G2, it's saying that published storage rates shall not be used to establish or otherwise influence the rates, and shall not be used to limit or suppress. This subsection 2 here is actually contradictory, and respectfully, I think it overreaches the bar's authority, because it's going down to evidentiary reasons. How can an average consumer, carrier, anybody, even a shop, go to a court and prove the ordinary and reasonable market rate? If this tool is out there in existence, whether or not it's made public or within the bar's private records, it's in existence and should be used as evidence. Otherwise, what's the point of this? It's illusory. There's no practical effect of this, and it would be, in my opinion, stricken or subject to being partially stricken on a declaratory relief action. So that is a big concern. I suggest that it actually should be reworked and reworded another way, such as published storage rates can be used as evidence of the ordinary and reasonable storage charges. The only shops I would imagine would be should or maybe afraid of this, for lack of a better word, afraid of this provision, are those, again, the unscrupulous ones who are charging the unreasonable fees. Because on the next page, you already BAR includes on 3351.8.2 subsection A3 that the BAR has authority to deem a storage rate presumptive. That is, sorry, is that the one? Sorry, subsection 2 there, A2. Storage rates can otherwise be determined reasonable by the BAR. So there's already that catch-all. So if there's an outlier out there, the BAR has every authority and is expressly reserving the right to make that determination, regardless of what else is out there, regardless of what the average rate is. And respectfully, I disagree with the earlier comment that carriers will not pay over the average, because that's not what happens. This is evidence, true, but again, unless there's a very unscrupulous fee out there in comparison to what is already there on the market in that locality, it shouldn't be at risk for judgment, or maybe there is room for negotiation, but that is what happens on the day-to-day. And for those practical disputes, the BAR has created the mediation program that the BAR can then step in and say yes or no. And carriers aren't the only ones that can use that. Shops can use that as well. So that there's already that process in place for, I guess, maybe those gray areas that are close to the average, but not so far out there that they're egregious. So those are my comments on that, and that it runs the risk, as written, it will be subject to litigation if this were to be published. It just will be, at the earliest opportunity, because of the risk that this creates. And it just flies in the face of consumer protection, in my opinion. So respectfully, but I believe this should be either stricken entirely or reworded in a way that it makes it available, for the public as evidence. And then turning to the next section on page 4, I'll just jump straight into A here, 3351.8.2A. This is a little clarification, because I do see some inconsistencies with how this is worded to include a tear down as a repair. I actually pulled up the CCR 3353 to where it references for the tear down, and nowhere in this section does it define a tear down as a repair. It defines it as an estimate. It also includes estimates for the cost of reassembly, as well as an estimate for the required repair that the teardown is designed to provide the estimate for. So I think the intent here is to include the teardown process as part of a market rate for storage charges. However, I think the word including a teardown should be changed to or authorization to perform a teardown, and leave it distinct. It's fine to include it if that's what the bar would like to do, but it should be, I think, changed, because the problem is the first line says when there's authorization to perform a repair and you do a teardown, but no repairs are ever done, such as you get the teardown estimate and it's a total loss, that there's no actual repair being done to the vehicle, and usually the vehicle is left in worse condition after that unless they pay for it to be repaired. So it's just the practical application of it. It doesn't make sense, and it seems to be inconsistent. So if you're going to accept that a teardown process as a distinguishing point to where shops can charge market rate, okay, but I just think the wording should be changed to make it clear, and not try to change a prior existing definition unless you're going to go back and change 3353C as well. That said, subsection A here appears to be conflicting with subsection C, because here it's saying in A that when an ARD obtains authorization to perform repairs, they're allowed the following shall apply, including when charging storage rates. But then in subsection C, it says an ARD shall not charge storage fees while the vehicle is undergoing repairs, including a tear down. So the way it's positioned in the text here, it's sounding as if, or it could be, it's a little ambiguous as to when a shop can actually start charging storage. Because if they don't start a tear down for a week, does that mean that they can charge storage for the first 7 days? Like, where's that line? It's a little unclear here, and I don't think that's the intent from our prior workshop conversations, but I think this needs to be reworked so that way there's more distinguishing factors on the timeline as to when it can be charged. Further, or buried in here on A3, I just want to bring up too the comment about the presumptively unreasonable, and it sounds like from what you were saying earlier that shops are trying to say that it can be rebutted with evidence, and if that's what the bar is going to adopt, I would suggest that there be a line of what constitutes rebuttable evidence, or what is needed to rebut that presumption. The fact that they have a forklift and a picture of it shouldn't be enough to charge a forklift fee. There should be some circumstantial reasons for why in this case, when it in all other cases it's presumed unreasonable, why in this case it's allowed. I'm not exactly sure what that should be at this point. I'll give it some thought and try to provide some feedback later after this workshop, but because this is new news. So, but if you are going to include the rebuttable evidence, I just think there should be some kind of quantifiable basis for that. So that way anybody looking at this will be able to tell, and an average adjuster or consumer can know and apply this. I have other comments, but I just want to also include that at the very end here, it seems that, because the big part that's missing here that wasn't missing at the last workshop was the storage rate and the context for charging storage in the public rate. Is it vehicle code 22524.5C2A, I believe, under the public CHP rate. All of that text is missing. It is buried here at the end but this is the only time it seems to be allowed is when a registered owner or their representative is unknown. That doesn't make sense and seems to completely sidestep the purpose of that vehicle code section.
Why doesn't it make sense?
It's gone. There's no reference to it here as to provide context when that applies, except for when the registered owner isn't known. And actually, it doesn't, some of the other comments I wanted to make, just real quick, is that the insurer, when a third-party payor is known, it doesn't obligate the shop to notify that third-party payor as written, because it expressly carves out an exception for that at the very last section here. But here, I would suggest adding either in 1.8.2, maybe at the end, or add a new section here when there's no authorization to perform repairs, that shall apply. Doesn't have to be very long, just maybe adding that context. I believe that was the intent of the last workshop in the conversations we've had at the prior ones. But here, there's no context. And in the vehicle code as written, there is also no context. So it would be helpful, I think, for everyone involved that be included to make it very clear when it does apply. Because right here, as written, the only time it applies is when the registered owner and their representative are unknown. So I will submit some other additional comments. But those are the big key points. And I do appreciate the bar's efforts on this, and I appreciate your time.
Thank you, Erica. Ben, you had your hand up next. Please just come forward to the microphone and introduce yourself and who you represent. Yourself.
Yes, sir. So my name is Ben Clymer Jr. I am from Southern California, representing Ben Clymer's The Body Shop. I would also concur. Thank you very much, because usually it's like one workshop. And so the fact that it's fourth and it doesn't sound like we're quite there. No, not to any lack of efforts on what you've been working on. It's just when you get all the stakeholders involved. So we appreciate the patience with this process on this issue, because as previously mentioned, it's a big issue. I think Jack and Pete did an excellent job representing our side of the story. And I got to hear some insurance concerns as well. So insurance companies, just like us, they're entitled to try and do their best to turn a profit, right? And so it may seem not relevant, my comment, but I bear with me, it is relevant. Nothing to do with your department, but the Department of Insurance. When they came down hard on carriers, it demotivated them to want to issue new policies in the state of California. In fact, many carriers pulled out of the state of California. And now with the local fires down in our neck of the woods, you have a lot of people that don't have insurance on those homes, and it stemmed from the unintended consequences, right? And so as mentioned earlier, there is some really good effort here, but the concern would be some unintended consequences. I do agree. I think the prior speaker, Erica, if I'm correct, made an interesting point on tiers. And the reason I personally think there is some merit to tiers is, for example, why would a shop like Ben Clymer's The Buy Shop have a different storage rate for EVs? So we have several Highline EV certifications. We do the Polestars, we do the Volvos, we do Rivians, we do Teslas. And so if you look at a vehicle that is an EV that's been towed in, and there's a possibility of a battery compromise, if you look at what's actually stated, it's not 50 feet away from a building, it's 50 feet in all direction. And so the last time I checked, that's a 100 by 100 box. And the last time I checked, that's a 1/4 acre. So if a shop that's doing it correctly gets 4 of those in, you're talking about only 4 of those vehicles per acre. So obviously that would be a different rate than, say, a non-hybridized Honda Accord, right? It would be different, and we work on those too. So I think there's merit to that, in addition to what was brought up in SoCal with big motorhomes. That's going to take up more space than your average car. I would also concur with the earlier point. Are we subject to the CHP rates, right? So I appreciate the effort on clarity there, because I do not believe that we are. I also then do share Erica's sentiment that it could have the unintended consequences with just going by the maximum versus like a tiered. And the reason being is, for the simple reason, if you have a shop working on these EVs, they're going to report a much higher rate, their maximum rate. Maybe a shop down the street that doesn't do any of these type of vehicles, they go on to the portal and see that rate. The unintended consequences is the carriers are going to pay the price, because then that other shop not working on those higher cost to store vehicles is going to want to match that price. And that would be bad for the carriers. So I do understand the point that was being made there. Finally, then, with the 3-day window, I absolutely agree. Just like I personally don't think healthcare is an absolute right to a person, in the sense that that person's body doesn't belong to me. I agree with what Jack said. I don't think that the 3-day window is necessarily a good idea, because we're essentially saying that person has a right to our labor or our bodies for that 3-day window. And on the 3-day window, and also I think it demotivates insurance carriers that don't have that agreement with those shops, like a contracted rate. I don't think it motivates them to get out there in a timely manner, so that all parties minimize the dollar fallout and the consumer gets their car back timely.
Thank you, Ben. You drove all the way up here today. Wow. Okay. Did anyone tell him there's a virtual option? No. It's good to see you here. Thank you. All right. Anybody else in the room? I'm going to open it up for public comments on the WebEx platform. Moderator, I'm sure you have some hands raised.
Yes, we do.
We'll open it up.
All right.
Yep. I'm going to ask, just in the spirit of, we've heard a lot of comments already, probably going to be repeated in some respect. If you have something new, that's the stuff I'm really interested in, or we as the Bureau of Automotive Repair are particularly interested in. I don't know if we need to, certainly feel free to echo something that's already been said. Ben did something like that, but kept it brief. Looking for succinctness in your comments. I'm suspecting we might have a bunch of commenters waiting. So to try and speed this along, moderator, I'm going to probably put people on a 3-minute time limit, so that we can try to get to everyone who has attended today and wants to have a little time to say something relative to the package.
Yes, point of order. Do you have legal counsel in support of the access issue? I certainly am not able to make a ruling on that.
The 3-minute timer, I thought you already had it going.
We suspended it for the first speaker, and no other speaker has been held to that standard.
Okay. Well, we'll see. Then I'll kindly ask everybody to, and at the point that I feel like we're getting overly repetitive with respect to the comments, I'll move to the next speaker.
Wonderful. Thank you very much for your help in that. And I am going to try and keep people in order of the reception of their request. First is Allison Addy. Allison, I'm going to send you a request to unmute. You're unmuted. You can go ahead.
Addy here on behalf of the Personal Insurance Federation of California. PIF greatly appreciates the difficult work that BAR is currently doing to develop these regulations on storage fees. It's going to help protect consumers, and we're really grateful for it. We've submitted comprehensive comments on previous versions of these draft workshop regulations, and today we have just 2 clarifying questions and suggestions. Can you please clarify BAR's ability to enforce these regulations in the event that a shop is not willing to comply, just for our records? And then, does BAR need more authority to levy fines or suspend a business license? Additionally, we think the regulation should make it clear that storage charges should not start until the vehicle is declared a total loss. Declaration of vehicle being a total loss should come from the insurance carrier, assuming that it is made within a reasonable time of the ARD advising the carrier of a supplemental inspection. Thank you very much for the opportunity and just those 2 questions for you.
And so, I feel like maybe that's not close enough.
No.
So yeah, we do have authority to take various types of disciplinary action based on the regulations that are being proposed once they become effective. And we have actually several choices. One would be the newly created ARD citation program, where any of the regulations that were violated would be subject to citation and fine based on those. I think we just propped up the ARD citation program back in 2023. So that would be one way we could deal with these through a citation, or under Business and Professions Code Section 984.7A, we have the authority to deny, suspend, revoke, place on probation a registration for violations of the Automotive Repair Act, but I think more specifically in this case would be 984.7A6 for any violations of the regulations adopted to the chapter. So I don't think we need any more authority than we already have.
And I would say, just to add to what you're saying, all of our regulation packages do not discuss the enforcement authority that we already have in both the Business and Professions Code, Health and Safety Code as it relates to the smog check program, and all of our regulations. To do so would be repetitive, duplicative, and probably shut down by the OAL attorneys. So it is already on the books, all of our enforcement authority and teeth to enforce, carry out our various regulations, including this proposed one once it's adopted. Was there
Thank you.
another comment?
Oh,
Okay,
yes.
no, I think we got the one about the storage not occurring until after deeming a total loss. Was that
That was a
Allison?
comment, not a
Yeah.
Okay, well, I was going to go in order of who raised their hand or submitted a question first. So,
Yeah, no, that's fine. I was just kind of,
Yeah,
I was just
sorry.
summarizing the comment from our last commenter.
Thank you. So our next commenter is CJ Rayburn, and I'm going to send you a request to unmute. Although if your microphone doesn't work, I can read your comments aloud, but we'd like to hear from you. And you're unmuted. Go ahead.
Can you hear me now?
Yep.
I was just wondering why everybody would say that an insurance company cannot use the average storage rate for a given locale. I think one of the previous speakers mentioned that insurance companies, I think it was Jack, he said that insurance companies are just going to use the average for a given locale. I think that's perfectly reasonable. And then the other question I had was, I'm wondering what all these repair facilities are doing currently for a hybrid vehicle or an all-electric vehicle. In my travels, including today, before this meeting, I was at 2 shops looking at electric vehicles and they were doing nothing different. So why would anybody owe more? I appreciate your time.
Thank you for your comment.
Thank you. And our next commenter is Francisco Velez. And if Francisco, I'm going to send you a request to unmute. If your microphone's not working, I will read your comment aloud. All right, Francisco, in case your equipment is not working, Francisco's question was, when determining whether an automotive repair dealer can charge storage fees while a vehicle is undergoing repairs, such as during teardown, does this mean we cannot charge storage fees from the date the vehicle arrives until we determine it is totaled, or can we begin charging storage fees starting from the date of teardown after determining it has been totaled?
Okay. Different parts there. First part is that, yeah, you would not be permitted, you are not permitted. I mean, it's not even, the regulations are just echoing, I guess, existing law theoretically, but specifically Owens versus Pion, which is an appellate court ruling from the 1960s. But The point is that while vehicles undergoing repairs, an ARD cannot charge storage. In the situation where you did a tear down, what we're trying to, our regulations are reflecting is that at the completion of the tear down, we have provided for a period of time, 3 days after the presentation of the itemized after the tear down, for a consumer to authorize the repair work, or storage fees would start at that point. I guess it could be something more than 3 days, just depending on the shop, because we just said a minimum of 3 days. But if you're asking if you have a vehicle in your shop that you've contracted to perform repairs on, meaning whether it's a tear down or if you actually accepted the insurance company's estimate as your method of repair, and at some point during that process it becomes a total loss, if you can charge storage fees back to when the vehicle first arrived at your shop, the answer would be no.
Thank you. And our next request is from GM Josh. And Josh, I'm going to send you a request to unmute.
Josh.
And you are
It's
unmuted. Go
Josh.
ahead. Yep.
You guys hear me?
Yes.
Okay, good. I'm from Knockout Collision Repair up in Northern California. I had a couple of points that I wanted to talk about regarding 3351.8.1 G1, where it goes through A, B, C, and D and talks about identifying average and median daily storage rates for a locale. Where my question is at is the locale, is that going to be basically like tow facilities, general repair shops, and collision all grouped into one locale basically, or will those different segments of the industry be separated out for what the average or the median for the storage should be?
So what we would require is, first off, it has to be an automotive repair dealer, as opposed to, well, I don't know how many tow companies, although some of them are. Most tow companies are not automotive repair dealers, so they wouldn't be included in the average. But now I guess you're talking about more like body shops versus mechanical shops.
Correct.
Yeah, the criteria would be whether you charge storage as a result of a collision or a theft recovery. Body shops fall into that category. Mechanical shops theoretically could fall into that category. In some situations, I'm thinking most probable would be like if somebody stole catalytic converters on a car and it got towed in. But I don't know how many charge storage, and if they do, I don't know what that count would be. I don't know that many of them are general ARDs or just mechanical repair shops are actually going to report, because I don't think many of them recognize that they would fall into that category, or actually that they even fall into that category. So anyway, that would be the answer.
Okay. No, I was just kind of curious, just sort of for that reason. I don't think general repair shops come into it as much as we do. I've been in a lot of general repair shops where I see they don't even, like, I've had general repair shops call me and say, what do I do? It's been 2 weeks. They won't call me. They won't pay me. They won't come and get the car.
Right.
So I'm just kind of curious. I'm not sure that they know a lot about that. My other, I guess, more of just a comment or whatever in regards to the in-house for CSAA or whatever carrier it was. On our end of it, insurance companies at best are taking 10 days or more to review when stuff gets sent into them before they make any decision about if they want to repair total. We're seeing stuff drag out for 2-3+ weeks before they come back and say, oh yeah, we think it's repairable, or can you get us more pictures of this or that or whatever. We can't afford to sit on those cars that long. Like, if that's the case, then the insurance carriers themselves need to do better. Like, they need to figure out how to process this stuff, look at it quicker. You know, our process is vehicle comes in, we put the estimate together within a few days, immediately send it to the customer and the insurance carrier. We start charging storage 3 business days after that information is submitted to both parties. It seems to be fair. We still have insurance companies that are allowing vehicles to rack up 30-40 days of storage, and we're on them constantly to come and get these things off of our property. So I get, and I've had insurance carriers say, oh, we don't want to, you know, you can't, we're the only one that decides it's a total. Well, no, it was a total from the minute it was in the accident. It's just a matter of moving it through the process to get the customer made whole. So that was my only, more of just a comment in that respect. But I don't think it's fair to say that an ARD has to wait for an insurer to decide whether or not the vehicle's a total or whether or not it's repairable. Technically, they don't even repair cars. They don't repair cars. They're not licensed to do it. They have a lot of information, but they're not the hands-on people. They don't understand it or see it the same way that the shops do.
Thank you for your comment.
And I did want to remind people, if you are a call-in user, you will press *3 to raise your hand. Others may raise their hand by clicking on the hand icon. Our next commenter in line is Jesse Parks. Jesse, I'm going to send you a request to unmute your microphone. And you're unmuted. Go ahead.
Hello, can you hear me?
Just barely. Can you speak a little louder?
I'd be happy to use my outside voice.
Great, thank you.
Thank you very much. One, I want to commend the bar for having the opportunity for people to have a voice. I've been to several of these now, and I think there's still a few areas where we keep getting hung up. A newer one is we keep considering these CHP rates, but the CHP rates, I mean, we have to keep in mind that this is a contractual agreement between two parties. So one party agrees to accept a rate to be on a rotation in exchange for referrals, and that is an agreement. So because two people make an agreement at whatever works for those two people, it's unreasonable for anybody that decides not to make that agreement to be held to any other person's agreement if it doesn't fit their business model. Will be the first thing that I want to say. When we look at what goes into holding a car for, Pete got into a little bit on what's involved when we have a car come in the shop. And there's a lot of bad actors on the internet and elsewhere that spend a lot of time talking about, the ways that some things happen with total losses. The reality is that they're the exception and not the rule. For everybody trying to operate a decent business, we have a lot of liability when these cars come in the shop. We have environmental hazards. We've talked about EVs. Ben Gleimer, I think you said it great. You got 4 cars, that's an acre of land. We have to now worry about personally identifiable information. We have to safeguard these parts so the insurance companies can maximize their salvage opportunities. We have limited space that also leads to loss of other repairable jobs. So I've heard Tiff speak a few times on this, and it comes up often, and it doesn't surprise me that they suggest that the storage should not start until the vehicles determine a total loss. The last time that I heard, I believe the same representatives speak, they said that the shops are causing these delays. And the reality of that is the insurance companies have all made a decision to move towards a model that is virtual. So they've cut their staff for their own business model and to maintain their own margins. And what has happened is we've had to absorb all of the admin labor. So we will spend 5, 6, 7 times going back and forth on an estimate just to get to where we were on the first time, and we beg them to come out. We're not the people that park it out back and hope they forget about it. The last time I talked about this, I said, I've offered to buy people lunch if they'll come out and look at the car. So and that leads into the 3 days of storage. And we talk, the representatives for CSAA threatened some litigation. I mean, nobody's talking about any kind of litigation. Could you imagine that if every insurance policy sold, you had to give 3 days free insurance on every policy that you sold? Putting it in comparison, I think is fair. I like a tiered system only for the EVs. Another example that was given was the beat up Camry. The beat up Camry still has the same value to the consumer. It still takes up the same amount of space for the shop, and it still takes the same amount of effort. So, that would be considered offensive to the person that owns the beat up Camry, and we still have to do the same work. So I think when we start looking at what kind of car they is, that's dangerous. I also have a lot of boutique EV certifications, and there's a lot more. I mean, I just had to order a defibrillator and a resuscitation bag because the risk of injury is so high. And there's a lot of additional things that need to be considered when we're storing these cars that I just hope you take into consideration. I had one more thing here. I'm sorry. Give me just a moment here. Yeah, I mean, the other thing too is related to fees, and I'm trying to bring up the code for that. Because as I mentioned, the insurance company now has forced us to go almost to a 1-to-1 admin to producer ratio because the demand on our administrative staff has increased to an unreasonable expectation. So when we talk about the work that is done with the customer, the communication, the insurance company, training their staff that generally has anywhere from 2 days to 3 weeks of experience, going back and forth. And I'm not trying to slam anybody here, but there's, somebody mentioned the forklift. Somebody has to buy that forklift. Somebody has to get certified on that forklift. Somebody has to get paid to move that forklift. And what's the alternative? To call another tow truck? Would that be fair to call another tow truck to move a car when you could charge not an unreasonable, but it would actually be a reasonable fee to move a car with a tow truck? So I think we need to look at fees, and we need to look at the evolution of our industry, of the additional administrative tasks that are being put on our shop, that we have to pay a lot of money to keep the people, so we don't, we're all fighting with turnover, and we're doing a lot of their job now. And just again, I want to reiterate that we work really, really hard to get these insurance companies out here to look at these cars, and the delays are coming from the insurance companies. So for them to say, the majority of the time, we work really hard, and they deal with staffing struggles too. But if they can't get out here, and then they want to say that this car shouldn't be charged until it's a total loss, that process, it's not uncommon for that on a non-DRP environment to take 3, 4, or 5 weeks. With that, I yield. Thank you.
Thank you for your comment.
And our next commenter is Josue, no last name. I'm going to send you a request to unmute.
That's Josh.
And there you are. You're welcome. Go ahead.
For me?
Yes.
Okay, perfect. I wanted to thank both the chief and the bar for helping us here today. I know this is kind of repetitive. We've already talked about the 3 days, and I just want to shine a little bit more light on that. Many industries charge immediate storage fees, and it's not uncommon for other people to charge the very first day. And I don't know why there's a 3 day, and I feel like the word free should be really thrown out there. It's giving out free. There's, like, for example, self-storage industries, they charge immediately if you default a day on payment. If you go to warehouse fulfillment centers or even store lots, if you leave a crate outside for more than a day and you don't pick it up, the shipping yard will charge you immediately days for storage. So these storage fees, even equipment rental or even rental companies, if you don't pick up the car at a dedicated time, so if you schedule 8 to 8 and you don't pick it after 8, well, you incur fees for being here delayed or not picking up in proper time. Same thing is here when the car is deemed a total. If we can actually communicate that to the customer the same day, I don't think why it's unreasonable to charge the customer storage the following day. If we tore it down the same day, told the customer the same day via electronically, via email, via text, or even verbal via phone. If the customer is aware of it, we got their consent, they understand it. Starting the next day, storage fees can incur. And it's much like the same way if you default on a payment. I think there share similarities in the principles of if you don't pay your rent on time, or how credit cards are allowed to charge fees if you don't pay, right? Even the very next day, they're unforgiving. It's because of lost revenues, right? The same way we're losing money to store the vehicle, the same way as penalties, late fees, and additional charges come from the storage fees. It's the same with us. It's loss of space, incurred security. We have to secure this vehicle. We have to incur the risk of it blowing up and then filing a claim through our insurance to pay the damages. And then also all security systems. The second one now that I want to talk about is the rates, how everyone has a standardized rate by dividing it. I think that's very similar to what there's a law already in place for capping. So it is against the law for insurances to involve themselves in capping just to a software system on the average, because it is not true to the real actual cost of repairing a vehicle for materials. So the concept behind that, for those who don't know, is there's various companies that do what's called a DEG. They publish their rates and they find out how much to charge for paint. The reason why the California law came to and chose not to cap in a body shop was because some can use better materials that have a lifetime warranty versus some that don't have any warranty at all, and it's just much cheaper. So putting an actual rate is not fair. So as long as you can prove the actual cost to the materials, the insurance must pay it. And this is very similar. If we can prove the actual cost of storing the vehicle, from security, from storage, from all that, I think there should be an exception in law that allows us to prove, because it doesn't show it reflect it. With that, I end.
Thank you, Josh, for your comment. I want to say one thing about Josh actually made a comment that I didn't cover when I was going through the reg text. He had one about had to do with our teardown estimates having to be written and leading to the belief that they couldn't, the way that the reg text was written caused a thought that it had to be in writing as opposed to a digital means or obtained over the phone. So it was something that we had a note on that we'll have to take a look at to see if we need to modify the text. So Josh had a whole nother comment in addition to the ones he shared with us today.
Yes, we had a good conversation with Josh down at the CAA chapter meeting in San Diego last week.
Yes.
Thanks for being here, Josh.
All right, our next commenter is Burley Cooper. Burley, I'm sending you a request to unmute your mic. There you go. You're welcome to go ahead.
Thank you very much. My name is Burley Cooper. I'm in-house counsel for CSAA. I appreciate the opportunity to speak briefly here today, and certainly appreciate the work over the past year or years by the Bureau and the stakeholders regarding the proposed regulatory language subject to discussion today, particularly in light of what appears to be all of us agreeing the impact, intended or otherwise. My comments here today will primarily relate to proposed section 3351.8.3. That's on pages 5 and 6. Before commenting on that, I will tell you from just from CSAA over the past 5 or 6 years, we have paid an increase in storage fees, just storage fees, of an increase of about 70 to 75%. And a significant portion of this is due to unscrupulous shops. We've got a significant litigation ongoing with that, but earlier there was some mention of unintended consequences, and I ask that is kept in mind from a global perspective regarding opportunistic or unscrupulous shops taking advantage of whatever proposed language is ultimately adopted here today. As we heard a prior shop owner say here today, with respect to repairable vehicles, look, the objective is to get completed vehicles out of the shop, back on the road in a timely manner, which includes retrieving them, which in turn facilitates more shop space, getting new vehicles that need repairs in there, and continuing that cycle. That's to the obvious benefit of the consumer, okay? And the benefit of, I think, all the stakeholders, including the shops. Shops don't want to sit on cars that are done. They want them out so they can work on other vehicles incoming. And it's reasonable for repair shops to assert storage charges if the vehicle isn't retrieved in a reasonable amount of time after notice of completion of the repairs. And in a significant portion of these cases, the insurer is known to the shop. So as we turn our attention to 3351.83, and bearing in mind that an insurer is a financially liable party under Vehicle Code Section 22524.5 for reasonable towing and storage charges, as presently drafted, 3351.8.3 uses the language upon completion of 3 unsuccessful attempts to contact the registered owner on 3 separate business days, and then it continues. And in the case, with the goal in mind to get completed cars out of the shop, notice is important, particularly when the insurer is known. And so my request for modification here is to change registered owner to registered owner and, if known, the insurer of the vehicle. Add them to the notice list. It's a quick phone call, an email. A lot of times the shops have already been emailing back and forth with folks with the insurers. And it's certainly not an owner's burden on the shop, but it vastly increases the opportunity for notice to go and get that completed repaired vehicle out of the shop in a timely manner. And there appears to be some internal inconsistency with respect to the term registered owner as used in the section I just discussed, 3351.8.3b. And then with respect to 3351.8.2b, and specifically D3, where the word consumer is used. And so if you take a look at 3351.8.2 D3, D3 is more or less the same thing as section 8.3. It says notified the customer that the repairs are complete. Well, in point 3, it says registered owner. In D2 here, it says customer. And I presume this is just an unintended but opaque interchangeability of the term customer versus registered owner. But again, my request for modification under D3 would be seeking it's a registered owner and, if known, the insurer of the vehicle. And I would also suggest that applies to 3351.8.2b, which states when obtaining authorization to perform a teardown, the automotive repair dealer shall inform the customer. Again, replace that with registered owner and, if known, the insurer in writing on the initial teardown estimate and the following information. And that's the bulk of my comments. I will address the request to eliminate the 3-day grace period and further written correspondence to this body. Thank you.
Thank you for your comment.
And our next request for comment is from Josue Jimenez. I'm going to send you a request to unmute your microphone. And Mr. Jimenez, you should get a pop-up on your screen. There you go. You're welcome. Go ahead.
Sorry, I clicked it in twice. You can go ahead. I think they haven't answered my question, but they'll answer it later. Sorry about that.
Oh, all right. All right. Thank you. And our last request at this point, although again, if a calling user would like to comment, you may raise your hand by pressing *3. If anyone else would like to comment, you can click on the hand icon and raise your hand that way. So our last is Dennis Gilman. Dennis, I'm sending you a request to unmute your microphone. And Dennis, did you see the pop-up? All right. I think we're going to have to go ahead and skip over you and go to the next person, who is Rick Johnson. Rick, I'm going to send you a request to unmute your microphone. And you're unmuted. Go ahead.
Can you hear me, folks?
Yes.
Thank you. I'm Rick Johnson. I'm the Executive Director of the Auto Body Association. Again, thank you, ladies and gentlemen, for this opportunity. Matt, I'm curious as to, I'm not big on new laws. I'm a little bit more excited about people enforcing existing laws. So under your current regulations, when you get a complaint from the insurance industry or the consumer as it relates to storage, how is this going to change your ability to enforce the current laws? In other words, what are missing under the current laws for you guys to go out and shut down these unscrupulous shops everybody keeps talking about. Seems to me like if we'd have put the energy into shutting these shops down, maybe all of us that are legitimately operating wouldn't have had to spend the last 2 years making regulations to take care of the crook. So how are these going to help you folks, or how are they going to change what you do now compared to what you think you can do in the future?
All right, so just one point before I move into how these regs will help us regulate the industry. It had to do with insurance companies can't file complaints. We have this referral process for them that actually is outside of the complaint process. But so I just wanted to make the differentiation so that people understood that there was a difference between what insurance companies would give us versus what we do for consumers. But right now, in order to take action or disciplinary action, when we take disciplinary action against a shop related to storage fees, the conduct that we have to meet would be what's actually defined in 984-7A section, right? So they made false misleading statements, that they, committed fraud, gross negligence, various things that fall within our authority to take disciplinary action. And that is not always the case, even if a shop is outside of what would otherwise be called reasonable. And these regulations are going to give express authority for the Bureau to make determinations based on the information that's available to them, and to be able to make recommendations based on their finding. And if a shop is violating these sections, to issue a citation or take disciplinary action if it reaches that point.
So at this point, under our current regs and with the new disciplinary action and fees, you can't do that currently?
No, currently, again, it has to rise to a level of theft, essentially, or fraud. And so that creates barriers to dealing with some of the issues that don't rise to that level. Let's put it that way.
Okay. You guys have talked about some of these unscrupulous shops have ARD licenses and aren't necessarily licensed towers. And then you talk about some body shops have tow trucks. So as it relates to the CHP rates, there's in the DMV code, the only time it refers to that, and this gentleman mentioned it earlier, they have an agreed on contract with the law enforcement agencies in the state of California to abide by these rates, because in the case, as Jack had mentioned, we have what we call non-consensual tows. In other words, they didn't order the tow, they may or may not be there on arrival, and they don't know what the amount is. So it protects the consumer from a tow that was authorized or non-consensual. Okay, so the other thing that these tow companies have to abide by, and some of us have had this happen, if you park in a tow-away zone, apartment, commercial building, there again, you didn't call the tow truck, you didn't know where your car went, so you're required to abide by those non-consensual rates. So only if a car was in a storage yard at a body shop and that car had got brought in by their tow division and never been engaged with the customer, would they fall under that non-consensual rate. Because you can call a tow company on your own and they can give you a price. And as long as you agree to that price, it's totally legal. So there's only 2 cases in the state of California where that law can be applied. And it's non-consensual towaway or a police rotation where they ordered that tow truck. So we're out of bounds here. And I think we've got an issue there.
So 22524.5 C2A, and I didn't print out this code section to bring with me. I guess I was short-sighted. I didn't know I was going to the differences between C2A and C2B. Having said that, the lead-in has to do with charging storage as a result of an accident or a theft recovery. And if you're wondering if, I've been saying for the last 6 years that if a body shop is in fact also a tow company, then they would be subject to those C2A, not actually C2B, because they have, for whatever reason, the language was in C2A led me to that position. Having said that, if that's not the case, I guess we will look into it and figure it out.
Yeah, you're correct. If they were the tow company, they went out on the initial tow and they brought it in, they would fall under that. But simply the fact that the body shop owns a tow truck wouldn't be that. And if the body shop was sent by the customer over to the towing yard to pick that up, that's consensual. The customer ordered that. So whatever they charge to bring that back over, that's consensual. Anyway, you can look into that, and I appreciate it. One more point. The legal representative for CSAA, I think, made Jack's case today.
Which one?
Okay,
Oh,
so
I shouldn't have asked. Just keep going.
when you collect and you average rates and you publish them, the government has now just capped a labor rate. And I don't think the bar is in the business of capping a labor rate. And both of the attorneys indicated that we need that, and they called it consumer protection, but literally so we can cap storage in any given neighborhood. That will be the most and the only thing they will ever pay. So now the government, along with giving away 3 days of my labor, by the way, if they break into the car and steal a stereo while I'm not getting paid, I'm responsible. Now you folks have just capped our labor rate as it relates to storage. The government is now in the business of price setting.
Well, thank you, Rick. It's always a pleasure to hear from you.
Sorry, guys. Appreciate your time. Thank you very much.
I smiled when I heard your voice. I heard your name. I hope you saw that on the camera.
Well, did you turn off the hotline yet?
Well,
Have a good
anyway,
day. Thank you.
You too.
Thank you.
Thank you.
And let's check in with Dennis Gilman one more time. Dennis, are you able to unmute your microphone at this point? And it looks like possibly not. All right, we're gonna, Dennis, you can look for the question mark icon down at the bottom of your screen and type your question in there if you need to. I'm moving on to Jeff Butler. Jeff, I'm gonna go ahead and send you a request to unmute. And you're unmuted, go ahead.
Thank you so much. Thank you to the bar for the opportunity to provide some commentary. I'm Jeff Butler. I've worked in the collision industry for 35 years. I'm a licensed public insurance adjuster and auto damage appraiser. I've worked both sides. I just want to start with an understanding, we all know, we all understand that there are bad actors in every segment of business. We want to prevent those bad actors from running rackets on the public. That said, the rules need to be fair to all the parties and encourage good faith action in the marketplace. With respect, and I've heard the comments, so I've adjusted my commentary to reflect what's been said. So repetitive, I'm just going to blaze through a couple of things here. With respect to the 3-day window that's been discussed, this rule would effectively make a repair facility's shop space free storage for that time frame. No business is in the business to provide free services. Insurers don't do that. If you don't pay your premiums on time and you miss 1 day, your coverage is denied, even though you paid for a lifetime, 40 years. You miss it 1 day, you're denied. Right? That's just an unreasonable expectation. I support the noted. There was an insurer that spoke, and I support the notice to the insurer if the insurer is known, who the insurer is. That includes the storage fees at the location the vehicle is at, terms and conditions. My repair facility has done that forever, and we send that notice every single time an email is sent. What our terms and conditions are, what the storage rates are for what segment, indoor, outdoor, on a frame rack, large vehicle, etc. So it's clear we're not just making stuff up. It's the same rates every time, and we explain what our terms are. If a bad actor is gaming the system, these kind of notification things will help keep bad actors at bay or help enforcement action against them. Insurers are required. So my next comment is that insurers are required to conduct a reasonable investigation, accurately evaluate the loss. When an insurer declines to accurately evaluate the loss or is in some manner incompetent or not acting in good faith, or just simply not refusing to see what is obvious in photos, because virtual claims handling is a pretty new, common standard now, and then weeks and weeks later declare a vehicle a total loss that was perhaps, by the shop's estimate, a total loss already. The rules that say you can't charge for storage up up until the time the cars become a total loss. Well, who's determining that? Well, the insurer is, of course. It's not the shop's ability to determine the coverage under the policy. That's the insurer's obligation. So I just want to make sure that there's rules in place that don't encourage gamesmanship on either side, and shops should be required to send notices, and insurers should be required to conduct a reasonable and timely investigation. The shop is the repair expert. If the insurer is not honoring the shop's repair estimate and then doesn't total a car for weeks, they're just gaming the system. I've seen it dozens of times, and that's my concern with that. Using the average storage rate at a particular location doesn't differentiate the market costs, different real estate costs. That approach it's just not going to reflect market prices. A business in a higher rent district would be relegated to perhaps what shops in a lower rent district are charging, kind of the same difference of a shop fixing high-end vehicles, has a giant investment, and versus a shop that just fixes bread and butter commuter cars. There's a vastly different standard. There's a vastly different rate. These just need to be market prices and reasonable. The last couple of comments, impound rates are not the same as consumers, crashed cars being towed into a repair facility, leaking fluids, antifreeze and oil, and that's not a same thing as an impound rate, and just shying away from a CHP rate because those are not the same circumstances. And the last comment I have is the bar acknowledged, and I read this in some of the publication, that the bar acknowledged that the consumer is required to authorize the repairs, and that's not the insurer, and that's correct. That said, keep in mind that insurers must timely investigate the loss and elect the remedy in the policy, that's repair or replace. So if we're going to start capping shops or talking about that, and I'm not for that, but I understand the bar's desire to protect the public and have fair rules. Insurers need to timely investigate the loss and promptly elect a remedy in the policy that's realistic and be prevented from engaging in gamesmanship that has a shop now, storing a car for weeks or longer, and you've heard that testimony. That just needs to be prevented with some more clarification in the rules. Thank you so much for the opportunity to speak.
Thank you for your comment.
And we can swing back through to Dennis Gilman, just in case third time's a charm. Dennis, are you able to unmute your microphone when I send the pop-up? It appears not. And then Josue with no last name, I do see you had one more item in the Q&A. You're welcome to present that verbally. And you're unmuted.
You guys hear me?
Yes.
Okay, yeah, sorry. My employee back there didn't finish my last train of thought, which the first one was that when you get capped in insurance for the materials, if you're allowed to prove, if you send, for example, a retail invoice, the actual invoice of what you paid for the paint, the tape, and everything associated, then that stands. And so that's how the law works. I was wondering if we can have that option to send to the insurance the actual, my rent, how much it costs, my training associated, my stalls, how many stalls I have, like the square footage, to prove the actual cost. Because like I think I said this in the last one, math is the most logical thing in life. You can't dispute math. If I can prove it, and you add my revenues, the opportunity cost, and you divide it the same way when I send the insurance an actual invoice of the actual cost of the material, of the actual cost of the tape. You take that to be the face value, then they pay that one. So I have the ability to dispute something. And the insurance, the law written protects me from the insurance doing that. So if you guys could write something in the same, look at that kind of verbiage of how they did it, then use the same one in this kind of law to protect us, to show the actual true cost. Like I've known a lot of people have mentioned, from electric cars to different rents to different trainings that we have. those are all opportunities that we can make those revenues. And essentially, going back with the 3 days as well, they all connected, is we lose money on that time. And those are things that we can pass down to the consumer because there's incentive for us to keep doing repairs better, having better equipment, and it pays off. So for example, someone says a car's on a storage rack, on a frame rack. Well, those frame rack costs $100,000. There's a loss opportunity. So we want to still be incentivized to keep doing better repairs for the consumer. So this is one form if you guys could protect the consumer and us, which we are here providing a service for the consumer. With that, I'll end it there.
Thank you, Josh.
Thanks, Josh.
And that is the end of the comments. Shall I close the public comment feature?
What time is it? I can't believe it. 4:05?
Yep.
My goodness. That's progress.
Very good comments, too.
Yes.
Thank you very much. All right. I think that will wrap us up for this workshop. Stay tuned for the next iteration of this. I'm sure there's going to be some changes based on the feedback we received. I want to point out, and some of the stakeholders have already made this comment. This isn't me, but you know when there's a little bit in this package for everyone, and then there's some pieces of it I'm sure that some have disagreed with. So it's a kind of a trying to appease or draft a regulation package that appeals to all stakeholders has proven quite the challenge, as we've found out, and as you've seen and witnessed here with, as Jack said, the unprecedented fourth regulatory workshop, and dare I say a fifth one.
Yeah, so would it be unprecedented if we did a fifth one?
Maybe, who knows? Anyway, as I said earlier in the at the opening, this will not be the last time. Even if we do not have another workshop, there is always the time an opportunity to provide feedback through in writing. If we post out the next draft, the next iteration of this package, and then there will be a formal filing where public comments are accepted in a much more detailed and required by law format for us to respond to each and every comment on the record that gets filed with the regulation package with the Office of Administrative Law. So stay tuned for all of those developments down the road. And thank you very much for being here, both in person and virtually through the WebEx platform that we have provided for this workshop. Look forward to seeing all of you again at a future meeting of either this or some other regulatory proposal from the Bureau. So have a good rest of your day and evening and weekend ahead. We'll see you at the next Bar Advisory Group meeting for some of you who attend those in April. Thank you very much. Bye.